Hubert Allen went to visit his brother at Henley Beach Esplanade in South Australia in 1953. He parked his car outside his brother's house, went inside, and returned to find that he'd been parked in. He didn't know it, but a group of young men had pushed the car, which belonged to Christopher Proudman, into that position so that they themselves could park and go to the pub. Proudman's car had been left unlocked. Allen went into the pub to see if he could find out who was responsible for the car, and the young men apologised for blocking him in. He assumed that they were the owners of the car. They went outside and the young men started pushing the car out of the way. Nobody was in the driver's seat. The car was on a slight slope and started running out of control. Someone yelled out, "Grab the wheel!" Allen, who had been lighting a cigarette, suddenly realised the car was in danger of rolling into a third car. He raced over, opened the door of the moving vehicle, tried unsuccessfully to apply the handbrake, then turned the wheel to steer the car away from the collision. Unfortunately, he turned the car towards an embankment down to the beach. Everyone watched helplessly as the car picked up speed, rolled across the narrow beach and wound up in the water. Proudman sued Allen for trespass to his motor vehicle, so trespass to Chattels. At first instance, the court dismissed the claim because Allen had acted out of necessity in the moment and had been trying to prevent harm to the car, not inflict it. Justice Hannon confirmed this decision, saying, "In principle, there seems no reason why the common law should not recognise an exemption from liability to pay damages for trespass to goods of volunteers or strangers who, from no other motive than the same desire to save the property of others from damage or destruction as they would feel if it was their own property that was in jeopardy, take reasonable steps on an occasion or urgent necessity to remove that property out of the way of danger or safeguard it by some other means." The case against Allen was therefore dismissed. From this case, we learn that it is no trespass to interfere with goods in an attempt to prevent their damage or destruction.